Good morning, everybody. I'm Myra Ansari here for Wave Now. We are going live to Frankfort at the Kentucky Supreme Court, where the Supreme Court of Kentucky, they're talking about the future of abortion rights in Kentucky. It's going to be reaching a defining moment when the state's highest courts hears arguments over a sweeping abortion ban put in place earlier this year. So we are going live to it. It started just a few minutes ago.
I thought it's so important to put that initiative on the ballot to amend the Constitution, because if nothing else, it costs thousands upon thousands of taxpayer dollars to do that. So what was important about that second question on the ballot to the General Assembly?
I think that the point...
I understand that you're arguing for the Attorney General and not directly for the General Assembly, but you've directly aligned with them in your arguments, and they are not here to answer the question. So unfortunately, Mr. Coon, I'll direct it to you.
Yeah, best I can tell, again, I don't speak for the General Assembly, was that the purpose of the ballot amendment was to foreclose an argument that our Constitution implicitly protects the right to abortion.
And by that, are you referring to the strong language about self-determination that appears in our state constitution, that's not in some constitutions and not even found in the federal constitution? Or what exactly are you talking about? Strategically and from a policy standpoint, I'm going to hope that the General Assembly had something in mind when we all went through that. So what is it?
So,
I mean, especially since your time is to ignore that it happened at this point.
So I'm not telling you to ignore that it happened. What I'm telling you is it didn't change the words. And so this court's task is the same the day before the vote and the day after the vote. Best I can tell, the abortion clinics have based their claim on the word liberty in sections 1 and 2 of the Constitution. And so that's their argument, that implicitly the word liberty guarantees a right effectively to elective abortion is the argument that they're making. And I think this court has been quite clear that when we interpret words in our Constitution, we look to the intent in 1891. Mr. Chief Justice, you wrote in the Claycomb opinion, the medical review panel opinion, that the Constitution's words should be given the meaning and significance that they possessed at the time they were employed. Justice Van Meter, you wrote in the Callaway County opinion, the Constitution should be interpreted, quote, according to the meaning at the time of its adoption of the Constitution. Now, I've had several arguments before this court where we've debated our Constitution's debates. Those matter in Kentucky courts. I think the point of all of that is there's not a single delegate at our debates that even suggested, implied, hinted at that our Constitution protects abortion. So I think that if the court is going to read an implicit right to abortion in, you have got to have historical evidence, and there's none at all from our constitutional debates.
Well, counsel, let me ask you. First of all, I think everyone would agree that history reflects there were no women. There were no women at the 1890 Constitution. Women did not have the right to vote in 1890. Women could not even own their own property in 1890, except in a narrow exception where you're an orphan and you're not married and you inherited property. Women were not considered. The word woman, the word women, neither one of those appear in the Kentucky Constitution. So I have some questions about the necessity of grounding our decision in 2022 on what occurred in 1890. I would point out, too, that at that time, and I think you've acknowledged this, the common law applied, and the common law did prohibit abortion, but it was after the time of quickening. And I've read these cases that have been cited, and Wilson, which was decided in 1901, and which recognized again, none of these, well, first of all, let's be clear. The issue before the court today, does the Kentucky Constitution protect the right? It's never been asked and never been answered. Even the Sasaki case, I always get that wrong, that was this court adopting Judge Max Winford as a federal judge, his analysis of the issue under the federal Constitution. So we don't have any precedent. Just like you said, your position is that the Constitution isn't pro-choice or pro-life, we definitely have no precedent that answers the question before us today. But to go back to your emphasis on the 1890 convention, which again did not include women, that was at a time where abortion was legal up until the time of quickening, which is generally considered somewhere between 18, 20, 22 weeks, somewhere along in there. And in Wilson, which I just referenced, the judge said to produce an abortion upon a woman is necessarily to endanger her life. Is necessarily to endanger her life. So we lived in dramatically different times. This was long before pregnancy tests, ultrasounds, all of the things that are just a part of what we in 21st century America know as the process of becoming pregnant and how you find out and what can be told about your pregnancy at any given point in time. None of that was even remotely envisioned. And the rights, if you will, of women weren't really remotely envisioned because they weren't there and they couldn't vote. There was even I've read a lot of the debates, there was even a big tussle over allowing two women to talk to the convention about the property right issue. And that was a big controversial thing, whether women should be allowed to address the convention. So is that not something this court can consider when deciding a 2022 issue following a ballot initiative where the people have voted no?
I want to make a couple points there. I want to address Mitchell, which you mentioned. I want to address Sasaki as well. At the time of our 1891 Constitution, of course, the technology was different. What we knew about pregnancy was different. We didn't have ultrasounds. We didn't know that a baby's heart started beating at 5 weeks. Those are all things that we've learned since then. But to be clear, abortion was an issue in 1891. In 1879, 12 years before this court, or before our delegates came to Frankfort to frame our Constitution, this court's predecessor, Kentucky's highest court, addressed the issue of abortion. So it was an issue that was being considered at the time. You're right, Justice Hughes, that that case, Mitchell, said that the common law does not protect or does not prohibit abortion pre-quickening. But I think you have to read the other part of Mitchell as well. Mitchell says quite clearly, 12 years before our Constitution was ratified, that the General Assembly can in fact prohibit abortion. So I think that's one historical marker that the court should look at in interpreting our history and our traditions. And I'll point out, yes, you're right about what Wilson said, but 9 years later in 1910, our General Assembly prohibited abortion at all stages with an exception to preserve the mother's life. And that prohibition stayed in effect for 63 years. And we cited the Grants versus Grauman case, which essentially says that when you have a long and uninterrupted tradition of allowing something in our Commonwealth, we have 6 decades of prohibiting abortion up until Roe, that matters in interpreting our Constitution, especially when that began so shortly after we ratified the Constitution. Now, I do want to address Sasaki 1 if I can. I don't want to hide the ball on Sasaki 1. I've gone back and looked at the briefs, hoping that they addressed a state constitutional challenge, and I've looked at them, and I'm not going to say that they did. But I would ask the court to look at the language that this court's predecessor unanimously used. I'll point out that this court's predecessor in Sasaki 1 did not like the total prohibition of abortion that existed at that time. They, quote, felt the statute could and should be reformed to more fairly recognize the interest of the pregnant women. That was something this court's predecessor said unanimously. But you know what they did? They upheld the statute unanimously. They said changing our abortion laws, quote, would be a matter for the legislature.
Well, let me jump in because there might be a lot of things that abortion, perhaps an unacceptable method of birth control, but obviously we adjudicate horrific criminal cases. In fact, have just in last year. So how do we square a line of thought like that with, say, the pregnancy of a 14-year-old girl that results from either like rape or incest?
So I don't want anything from that I say from this podium to take away from the criminality and the involuntariness and how terrible that is. And so nothing I should I say should take away from that. You're right, Justice Van Meter, that the trigger law does not have an exception in those tragic circumstances. Let me make a couple of points on that. First, as I was talking to Justice Nickel earlier, the General Assembly has not had a chance to meet in a post-ops world. And I mentioned Indiana, I didn't get all the way through. Indiana enacted an abortion law post-ops, and they included an exception for rape and for incest. And so I think it's important to give our General Assembly, the policymaking body, a chance to weigh in on this.
Well, Council, and I promise one other question, I'm not going to monopolize this, but the General Assembly drafted this proposed amendment. It was totally within their control. And in response to your question to Justice Nickel, well, this is really for the legislature to take it from here. The proposed constitutional amendment wasn't, there shall be no right to an abortion in the Commonwealth of Kentucky. The proposed constitutional amendment was about nothing in this Constitution shall be construed to secure or protect the right to abortion. And the construction of the Constitution is not in the bailiwick of the legislature. It's squarely within this court's responsibility. That's our role, is to construe the Constitution. So I respect what you're saying, and that the legislature has a role in responding to Dobbs and responding to what happened last Tuesday. But the way this is drafted, we definitely have a role in that as well. And it's a question that has never been answered in Kentucky. The constitutionality of a complete, and that's what we have right now, a virtually complete ban on abortion. It doesn't recognize an exception for rape and incest. It doesn't recognize an exception for women who are under the care of a physician who tells them that the standard of care would be to terminate the pregnancy. It doesn't recognize those people. It doesn't treat them any differently than a scenario where a woman decides, and there are affidavits regarding the women who have made those choices. Maybe they decide for their own health reasons. Maybe their doctor's not saying it's medically necessary, but there's the one woman who has 2 young children and has struggled with pregnancy before. She can't care for her children and go through another pregnancy. People make that decision, and according to the statistics that you gave us in your appendix, the last statistics from 2020, 93% plus of the abortions in Kentucky occur at 15 weeks or earlier. They occur in that very early part of the pregnancy that is consistent with the Commonwealth or common law understanding of quickening. And in fact, the legislature has passed a 15-week bill. It's on the books.
So the sort of the narrow circumstances that you're bringing up, we do have a health exception under both of these abortion laws. This health exception tracks the health exception that the U.S. Supreme Court upheld in Casey. It's essentially the same health exception that's been in place since 2017 for our 20-week law. And I want to be clear, that health exception depends on the reasonable medical judgment of physicians. There's been a lot of misinformation out about health exceptions. The Attorney General, who enforces these abortion laws, has put out 2 advisories explaining to doctors how these health exceptions work, pointing out that preeclampsia, of course you can do an abortion then. Of course you can do an abortion when there's an ectopic pregnancy. We've been quite clear that IVF is not covered by this law in any way, shape, or form. We've been clear that what's commonly known as emergency contraception is allowed under this law. So again, there's a lot of misinformation out there about health of the mother. And the law has an explicit exception for that, and we are continuing to work with Kentucky doctors, giving guidance on that. I do want to point out, though, with these exceptions, Chief, sorry. Yeah, in this response to Justice Van Meter's point as well, our laws are amenable. The courthouse doors are open to an as-applied challenge to these laws. That's not what we have here. An as-applied challenge that says our laws are unconstitutional in narrow circumstances, tragic criminal circumstances of rape. I understand that the court has to address this issue now. I would remind the court, we're here on a temporary injunction. And I think the court, because the equities matter, if the court's concerned about the lack of a rape or incest exception in our abortion law, the court, I could envision an opinion that says the equities in those narrow circumstances are quite different because of the criminality, because of the involuntariness. I do think the court would be well within its rights to not affirm the injunction, but narrow it to apply only in those narrow circumstances of rape or incest. I think that the equities at this stage would permit the court to undertake that action. Chief, sorry.
To your point earlier, that the General Assembly has not had an opportunity to address this issue post-Dobbs, and that rape and incest was, but don't help my memory here, wasn't there an amendment to address rape and incest at the time of the adoption of the trigger law, and it failed?
So I'm not going to hide the ball. I think there have been various votes over the years.
This was last a few months ago.
There was one with respect to 2022 House Bill 3 that failed. And the first case I argued before this court was a statute had failed 6 times, and then they finally passed it. So I think we expect our General Assembly, as a Kentuckian, as all of you are, that they are continually monitoring the situation, that they are responding to the situation on the ground. My understanding is that a bill including a rape or incest exception is going to be pre-filed, hasn't been pre-filed yet, but a legislator has reached out to the Attorney General's office for guidance on drafting that. I think we're going to see that. I think I don't speak for our General Assembly. I can't tell you what they're going to do in that tragic circumstance, but Indiana included a rape or incest exception. And I would urge the court to let our General Assembly address this issue. And if the court's concerned, your remedy is not to affirm, but just to narrow to apply in those circumstances based on the equities.
You talked about a faith, but especially when you're talking about a tragic situation of rape or incest, by the time they challenge to get up through the courts, the tragedy would have occurred. I mean, it's just not possible. And to follow up on Justice Fanier's question, I mean, he mentioned a 14-year-old, but the reality is this court sees 10 and 11-year-olds who are impregnated by rape and incest. And that's not just an issue of the issue of preserving life, that's an issue of safety and health. In most cases, it's just not safe or healthy for a 10-year-old child to carry a child. And our Constitution does specifically talk about self-determination in reference to one's own safety. And that's in the very first section of our Bill of Rights. And I can't overlook that compelling language. Additionally, I'm not sure what you all would tell the medical community. And in a way, the vote on question 2 is beyond the record, so to speak, that happened out there in Kentucky, not within the record of this action before the court. But what's really happening is physicians in emergency rooms all over the Commonwealth are calling the risk manager and the attorneys for the hospital, not knowing what to do. And sometimes minutes and seconds matter. And sometimes the risk manager isn't available. Sometimes the attorney isn't available at 3 in the morning to give a cogent answer. This exception for the life of the mother does not allow the mother to make any of her own decisions. The decision is left up to whatever physician is on call when the life-threatening emergency arises, with the caveat where the physician is instructed in the last sentence of that section about preserving the life of both the mother and the unborn child. Now, on a moral basis, I might completely agree with that, but I think you're obfuscating what this trigger statute says. There isn't a strict life of the mother exception. This exception is left up to whatever physician is available whenever a life-threatening emergency arises. And from my experience working in life-threatening emergencies as a nurse, they don't always arise 9 to 5. They arise 7 days a week, 2 and 3 in the morning, and the physicians don't know what to do. doctors are calling the Attorney General about what to do. That's a medical decision. And if there's a man bleeding out in the ER, he has all the self-determination in the world, and most women do too, unless they're in a state of pregnancy, and then suddenly there is no self-determination. And then the physician's trying to get a hold of the Attorney General. So I think that people should read that exception for the plain language that it states.
And let me focus on the plain language. The determination is based on the language as a reasonable medical judgment. The practice of medicine, as you know from your time as a nurse, it's based on risks. It's not based.
Time, though, any other, I agree with you. I defended for 17 years physicians in the issue of reasonable medical judgment, but I know of no other time when the patient themselves does not collaborate with the physician during the exercise of reasonable medical judgment. I know of no other time, other than for a minor or an incompetent under the law, and then the guardian will be collaborating. There was no other situation in which reasonable medical judgment is the end all. It's always with the collaboration of the patient in reference to their care. Except under operation of this statute right now in the Commonwealth of Kentucky.
And I think the issue, I agree with you that the issue of abortion is different. And another thing that's different about it is that there is an unborn human life at stake. And so in that sense, I think you wrote in your separate opinion that it's balancing interest on both sides of the equation that are heavy and that are profound. And abortion is just unlike any other issue, right? If you allow an abortion, you're always going to affect the pregnant mother. And if you allow an abortion, you're always going to affect the unborn child. And if you prohibit an abortion, you're always going to affect the pregnant mother. And I think it's just line drawing in this area. It's very difficult. It's value laden. And I think that the difficulty of it and the fact that people disagree so vigorously, as we saw last Tuesday, I think that all cuts in favor of the court not stepping into this issue. This court, the last time it had an abortion case before it, it was not the legality of abortion, but the court in 2016 wrote unanimously.
I don't disagree with anything you said. I just want to make it clear that I think you misrepresented the nature of the exceptions of life. I think we cleared it up here, and I think that was an important clarification. And it has nothing to do with the balancing of the moral equities, in which I wrote it all cognizant of.
And Justice Keller, I don't want to be, I don't want to misrepresent. I would urge the court, as you look at the health exception, to look at the advisory, the statewide advisory the Attorney General issued at the
I
end
don't
of June.
remember the last time the Attorney General had to advise physicians on how to save lives or not. It hasn't happened in my lifetime. I hope it doesn't happen again.
And I think the fact that we had to step in, we're trying to clear up the misinformation. And again, abortion is different, as you're pointing out, but it's also different in the fact that an unborn human life is at stake every time. 4,102 abortions in 2020, 280 abortions based on the restraining order and temporary injunction issued here. This is an issue for the people. The branch of our government that's most responsive to the people is our General Assembly. They haven't met yet. I'd urge the court to let them meet. Thank you, Mr. Chief Justice.
Just one question, if we could shift from a heavy moral issue, perhaps, and a heavy legal issue to a more heavy legal issue, if you will, that's sort of a foundational issue that I'm having difficulty with, and that is the issue that you led off with in your brief, and that is the third-party standing issue. If you could address that briefly at the end of your argument, I didn't want you to just be limited to that in your closing.
Yeah, and I appreciate that question, Justice Lambert. This court since Sexton has been quite insistent on finding a party with standing. And 2 months ago, this court issued the Bradley ruling. It was a unanimous ruling of this court. And what the court said in Bradley, and I want to quote, the party, quote, seeks third-party standing to represent unspecified third-party clients without any argument that these clients are unable to represent themselves in the courts of this Commonwealth. My point is, on this record, in light of Bradley, we do not have any evidence that pregnant women cannot represent themselves in the courts of this Commonwealth. As we noted in our blue brief, the Attorney General has already been sued about our abortion laws by 3 women in Jefferson County. The abortion clinics here attach pseudonymous affidavits. That shows that women can sue pseudonymously to challenge our abortion laws. Pseudonymous litigation is a staple of abortion litigation. Roe versus Wade is the example of that. And I think that this court, since Sexton has been insistent on a party withstanding, this court's going to get the issue that we're arguing today someday, and maybe soon, but I don't think today is that day, because we do not have, the abortion clinics on this record do not have third-party standing. Thank you.
Mr. Chief Justice, and may it please the court. My name is Heather Getnerick, and I represent EMW Women's Surgical Center and Dr. Ernest Marshall, though I'm appearing here today on behalf of all appellees. As a frontier state, Your Honors, Kentucky has a long and proud history of jealously guarding the individual liberty rights enshrined in our Constitution. The circuit court below was correct to note that the right to privacy has been consistently recognized as an integral part of the guarantee of liberty in our 1891 Constitution since its inception. Our constitutional protections can be interpreted more broadly than those allowed for by the federal Constitution, and that is specifically so with the right to privacy. The circuit court below was also correct in its application of the CR 6504 Maupin analysis in this case, and granted a temporary injunction to block 2 extreme abortion bans. That injunction should be reinstated and upheld. First, as 6504 requires and the circuit court found, appellees, the moving party below, demonstrated irreparable injury to their patients and to themselves. Patients' irreparable injury includes being forced to remain pregnant against their will, facing physical and mental health risks and the pain and trauma of a birth they did not choose, or taking on the additional cost, time, and hardship to travel out of state to access abortion care if they are able to at all. And the provider's irreparable injury includes being unable to provide moral and ethical health care to their patients without fear of criminal prosecution or loss of licensure. Second, the circuit court balanced the equities in this case and correctly found that those equities weigh in favor of an injunction by considering the possible detriment to the public interest, alleged harm to the defendants, and the maintenance of the status quo, which is the nearly 50 years that Kentuckians enjoyed the right to legal abortion under the then existing Roe framework. And third, the circuit court considered and correctly held that the providers have raised a substantial question on the merits going to our constitutional claims, both with regards to the unlawful delegation claims under sections 27, 28, 29, and with regard to the privacy self-determination claims under sections 1 and 2. And indeed, as has already been discussed here this morning, just last week, the voters of Kentucky declined to remove protections for abortion from our Constitution. Finally, the court below considered and correctly held that the providers have standing, themselves and third-party standing, to bring claims on behalf of their patients. Providers have injury in fact themselves and therefore standing to bring this challenge because the criminal penalties and the adverse licensure actions in the bans go to the providers directly. So not only do the providers have standing then, but they are in fact a necessary party in order for an injunction to mean anything at all. And they have third-party standing because the patient's constitutional right to an abortion is inextricably bound up with the provider's ability to provide that care. And there are critical reasons why patients are hindered from raising claims themselves, including, but certainly not limited to, the imminent mootness of those claims.
Counsel, if I could, federal case law has long recognized the third-party standing of physicians who provide abortions in cases there was some language in Dobbs that opposing counsel raises and says, well, and I understand your first argument is that they have standing in their own right. But with respect to the third party, did the Dobbs decision in any way undermine all of that precedent?
It did not, Your Honor. The language cited from Dobbs was dicta, but even so, what was being called into question with that dicta language from the Dobbs decision is the fact that for decades, federal cases have routinely granted abortion providers third-party standing to bring claims on behalf of their patients. If anything, that language from Dobbs suggests that perhaps the court not adopt a bright line rule that abortion providers always have standing to bring claims on behalf of their patients, but that the courts instead engage with the analysis for third-party standing, including injury in fact themselves, close relationship between the parties, and whether there is some hindrance. And indeed, Your Honors, that is what we invite the court to do here today and what the circuit court below considered. There is an incredibly close relationship between the litigants here and third-party patients' ability to exercise and access their constitutional right to abortions. And there are hindrances to people's ability to patients' abilities to come into court and litigate on their own behalf. As I said, that is including but not limited to the imminent mootness of these claims. Pregnancy is, of course, a very time-sensitive medical condition, and the window of time in which people can access abortions is even shorter. It is impractical to suggest that a patient, between the time they find out they're pregnant, make a decision to have an abortion, and before they're time limited by whatever the upper limit of gestational age would be, are then able to go to court and get a court order allowing them to access that care. But that's not the only hindrance, Your Honors. As the court noted, there are hindrances that include patients' interests in remaining private and not rushing to court to have to get a court order to access this private medical decision. And the U.S. Supreme Court in both Singleton and again in Craig give us language that I think is especially useful here, which is to say, first of all, hindrance does not need to be absolute. It does not need to be insurmountable. There just needs to be some hindrance to a third party's ability to go to court themselves and litigate their claims. But also, where the claims are already before the court, where the constitutional claims are already before the court being argued vigorously and cogently, and I would suggest that they are, Your Honors, by the party before it, it is not an efficient use of judicial resources to wait for another party to come before the court, to send the case back and seek, for instance, a representative class action. And if in fact a class action is designed to be representative anyway, which would likely be necessary because of the mootness issue that we've already discussed, the Supreme Court has said it is sufficient to allow providers then to bring these claims with third parties.
What about the decision in Bradley that Mr. Penn has already referenced that I'm sure you read just from a month or so ago, and then also the pending case that's already been filed in Louisville?
Thank you, Your Honor. The Bradley case is one of many in which this court has favorably cited federal case law that does expressly allow for third-party standing in some instances where it is appropriate. So Bradley, again, this court cites, for instance, Worth v. Selden, which is a U.S. Supreme Court case that says in a number of instances third-party standing may be appropriate. In some cases it's not, but here it is. The Bradley case did nothing, Your Honor, to foreclose that, to say that third-party standing is never available, but of course, Your Honors held that it wasn't there, and partly that was because the plaintiff in that case was seeking associational or representative standing to bring claims on behalf of the attorney members of the Bar Association for which she was the president, and this court said, we already don't think she has that standing, but also there's been no evidence that the attorney members of the Bar Association have third-party standing on behalf of their clients. This is a much different situation, Your Honor, where we do have standing ourselves, the providers have standing themselves, and third-party standing is exceedingly appropriate given the close relationship and the hindrance here. With regards to the Sobel case from Jefferson County Circuit Court, Your Honor, a few things. The claims there are very different than the claims we've brought. The plaintiffs there are seeking different relief, and their claims are not the same as ours. They are not seeking the same constitutional right to an abortion under the Kentucky Supreme Court that we are. They also are not seeking injunctive relief. It's a declaratory action only. There is no telling then when there may ultimately be a final decision. And finally, maybe most importantly, the factual circumstance is much different. The plaintiffs in that case are 3 women who are seeking to use IVF treatments to grow their families and are concerned that the bans currently in place in Kentucky may impact their ability to use IVF. They are not currently pregnant. My understanding from the case is that they are not currently pregnant, and they certainly are not currently seeking an abortion. So the issues are very different, and factually what we have is a much more urgent matter before the court now that requires consideration of this issue, and at the very least requires, Your Honor, a reinstatement of the temporary injunction while this case returns to the circuit court, because there are very real harms happening right now while these laws are not enjoined.
The very fact that the Attorney General's office has been called upon to make some clarifications, as we've heard earlier today, does that signify to you that there's some vagueness involved here then, if I'm understanding the argument you just made?
Yes, I think that's right, Your Honor. And the record from below indicates that there actually is some agreement here between plaintiffs, police expert, and the Attorney General's expert to suggest that doctors should not be placed in a situation where they are left to wait to watch their patient deteriorate before they may meet one of these very narrow exceptions in the ban, in the 2 bans that are currently in place. And more to that, Your Honor, the Attorney General's advisories are just that. Those are not binding. They certainly, I do not believe, would in any way bind all the other prosecutors in the state who would also have the ability to prosecute if they believe there was criminal wrongdoing with regard to an abortion. And absent some binding interpretation of what these laws mean, I don't think that providers in the state can rely on the Attorney General's advisories. But I absolutely agree, Your Honor, that I think it makes crystal clear what the issue is for providers on the ground right now. And we know that providers' hands are being tied. We have, the court has before it an amicus from 2 of the major medical professional associations, the AMA, American Medical Association, and the American College of Obstetrics and Gynecology, which both say this is not how we practice medicine. This is not what moral, ethical healthcare looks like for our patients. We cannot wait to call the attorney for the hospital when we have a patient in need. And again, as defense expert agreed at the evidentiary hearing on July 6th, it is not proper medical care for a provider to wait until their patient deteriorates to a point that they may then meet one of these exceptions. Doctors are supposed to treat their patients holistically and with an eye towards the patient's needs, interests, self-determination through that time, and they are currently unable to do so while these laws are not enjoined.
Counsel, you mentioned earlier about gestational appropriateness. I think maybe that was your language, but I'm wondering, and maybe get ahead of ourselves because it is a temporary injunction, but what is EMW advocating for in reference to that? Is it access? Is it wide access? Is there a line to be drawn? Is it up to this court to draw the line? Would that line be found within the Constitution? I can't imagine it is. What is your position on that?
Well, Your Honor, because the right to abortion rests within our privacy and self-determination rights within sections 1 and 2 of the Constitution, it would then follow that a strict scrutiny analysis would apply in challenges like the one that is before the court here. We're before the court on a temporary injunction, but the underlying claims here would call for strict scrutiny. And of course, as this court is very well aware and familiar with, strict scrutiny would require considering whether the state has a compelling enough interest to outweigh an individual's fundamental constitutional rights. And the self-determination cases, Woods, DeGrella, show us that this is a consideration and an analysis that will look different at different stages. So for the court to ultimately consider in this case, I think, will be at what point in pregnancy does the state's interest in protecting potential fetal life become compelling enough to outweigh an individual's rights to make their own determinations about their bodies and about their pregnancies.
Counsel, let me ask you, as you said, the American Medical Association and the American College of Obstetricians and Gynecologists filed a brief, and two of the points they made, they say, as a matter of medical science, a true fetal heartbeat exists only after the chambers of the heart have been developed and can be detected via ultrasound, which typically occurs around 17 to 20 weeks gestation. They also say that most major fetal anomalies are not detected until after at least 11 weeks of gestation. Obviously, we haven't had an opportunity to review the full record below, and it is just a record on a preliminary injunction. But is there anything in that record that's inconsistent with what the American Medical Association is saying with respect to fetal development? To your knowledge, I realize it was a 1 day, 2 day hearing. I can't remember, but
Thank you, Your Honor. It was 1 day. I can't recall if there was any. There was certainly nothing directly contrary. Let me say that. I think, to be frank and in candor to the court, there is a difference in how the experts discuss these matters,
Right.
Plaintiff's expert and the defense expert. But I think it is widely accepted among doctors and the medical profession that what the 6-week ban at issue here calls a fetal heartbeat is actually more like embryonic fetal cardiac activity rather than a true heartbeat, because as the AMA ACOG brief tells us, that doesn't develop until much later in the pregnancy. And again, the only two laws at issue here, Your Honors, are the trigger ban, which bans all abortions from the moment of conception, and a 6-week ban, which bans abortions after 6 weeks LMP with last menstrual period, which is before many people know they're pregnant.
So this temporary injunction addresses itself to the two most recent pronouncements by the General Assembly. There still remains out there the 15-week ban, correct?
That's correct, Your Honor. The 15-week ban does remain in place due to there's a federal proceeding happening in the Western District of Kentucky right now as well, which challenges parts of the most recent ban, which was House Bill 3. House Bill 3 from this year is also the most recent example we have of a rape or incest exception being introduced as a floor amendment and being defeated and was not adopted in the passage of that bill.
so that was the KRS, the 15-week bill is KRS 311-782. And it has no rape or incest exception.
I'm not sure of the KRS number, Your Honor. I apologize. I can grab that for you. But it was House Bill 3 from this year, which was a 72-page bill. So it has resulted in a number of different statutory provisions. But yes, that bill, House Bill 3, had a floor amendment with the rape and incest exception that was defeated.
And as I'm reading it, the medical emergency exception is to prevent death or avoid a serious risk of substantial and irreversible impairment of a major bodily function.
That's right, Your Honor.
Consistent.
Why would not, if we agree with your argument and we strike down the trigger ban and the 6-week ban, and basically we go with the idea that there's a right of privacy and self-determination, then why does that not then strike down? Ultimately, that will strike down the 15-week ban. And there'd be no line drawing at all. Why is that not the natural progression of how we do that?
To be clear, Your Honor, I'm not suggesting that there would be no line drawing. I think there would be a time at which the the court would likely find that the state's interest becomes compelling enough to outweigh all those individual privacy and self-determination rights. So there would be some point at which bans after a certain gestational age would be upheld, because at that point the state's interest would be compelling enough.
Then why is that not ultimately the line drawing exercise for the legislature? You know, if they're going to draw it at, let's say, 22 weeks, what about 21? What about 20 and a half? What about 20? I mean, isn't that ultimately the role of the legislature in public policy?
A few points to that, Your Honor. First, it is the role of the legislature to legislate, but they must do so within the confines of what this court tells them is constitutionally permissible. And as was previously discussed, this court has not yet had a chance to speak or to issue an opinion on what the protections within sections 1 and 2 of our Constitution mean with regard to the right to access an abortion and make your own determinations about your body. We know that this General Assembly feels comfortable passing total abortion bans because that is what they have done, and that is why we are now before the court. Not only do I think that it might be, let me say, we do not yet have before us any evidence that this General Assembly is interested in undertaking a thoughtful balancing between the state's interest and individual privacy and self-determination rights. But even so, with these laws currently being in effect right now, there are people being harmed in Kentucky. And the circuit court below did not err or abuse its discretion in finding that, at least at this temporary moment in this case, an injunction is proper in order to prevent these harms to Kentuckians.
How do you address the argument that abortion, it was a total, more or less a total abortion ban in 1910, very, very close in time to the 1891 Constitution that was in place for 63 years until Roe v. Wade. So if there's a right to privacy and self-determination that exists now, it had to exist then, correct? So how do you address his argument that the way the Constitution's been interpreted for a long-standing time is also an indication of how it should be interpreted?
First, as was previously discussed, at the time of ratification of our current Constitution, abortion was permitted, at least up until quickening, which by any definition is beyond the point that these laws take effect, or even the 15-week ban would take effect. But secondly, Your Honor, that is precisely what this court addressed in Wasson. Wasson, which of course was the case that held that our state constitutional privacy right protects same-sex conduct, even at a time when the U.S. Supreme Court said the federal Constitution does not. Wasson was decided in 1992, and since 1860, for 130 years prior to this court's decision in Wasson, same-sex conduct had been criminalized and had been prosecuted. That long-standing history, Your Honor, was not the ultimate arbiter in the case. This court did not rest on, well, it's been outlawed for 160 years, so therefore it must be constitutional. As in Wasson, we now have a situation where the question has not been put to this court. And Your Honors have said in previous opinions that it is a constitutional duty of this court and would be an abdication of its duty not to consider constitutional rights like this when presented by parties and when there are cogent claims being argued before the court. So first of all, when the Constitution was ratified, abortion was permitted, at least up until quickening. But secondly, even if it had not been, and there's no evidence that it was outlawed because it wasn't, even if it had been, that wouldn't have been the end of the inquiry, because that's what this court addressed in Wasson.
Counsel, if I could, going back to Justice Van Meter's first question, if we were to affirm the injunction that the trial court entered, that would have the effect of prohibiting the enforcement of the trigger law and the 6-week law. But wouldn't that leave in effect this 15-week ban that we're talking about that was passed by the legislature just actually a few months ago? It's not like affirming the injunction that was entered by the trial court would result in no laws on the books. I was looking over the weekend, 50 pages of the Kentucky statutes, 50 pages are devoted to abortion. And so if these two are, if we affirm the trial court and there's an injunction on the enforcement of these two, there are still plenty others. There's a 20-week, there's a 15-week, and these would be things that members of the General Assembly passed, not something that this court made up. They're on the books.
That's exactly correct, Your Honor. The 15-week ban would remain in place if the injunction were to be reinstated. And I think we all know that abortion is an incredibly heavily regulated area of medical care in the state. There are a number of laws and restrictions that have been in place, that will remain in place if abortion is again available in the Commonwealth. And there are a number of laws on the books in Kentucky that have never been subject to legal challenge, even under the pre-existing Roe and Casey framework. So there will certainly be, as there has been for many, many years, a high degree of government regulation of abortion, but at least people will be able to access this care and make the decisions for themselves, whether to give birth and have children. And I think I just also want to mention to your honors the importance of, again, what brings us here today, which is that we are before this court only on a temporary injunction from the circuit court, which your honors have said time and again, circuit court orders on injunctions are due great deference. And there's a reason for that, because the circuit court had the ability to hear from live witness testimony, to review the evidence before it, to review the parties' briefings both before and after that July 6th hearing. And based on all that, made the determination that it felt it was a proper balance of the equities, that plaintiffs have raised a substantial question going to the constitutional merits, and that there is real irreparable injury happening in Kentucky when people are not able to access abortion care. The evidence is largely undisputed in the record below of what it means to be pregnant, what it means to endure pregnancy, even a very wanted pregnancy, and to force that on Kentuckians without allowing them access to this care, even in situations where someone is pregnant as a result of rape or incest, even in situations where people are having to make decisions about pregnancies that they know will not survive, is this court properly found irreparable injury that can be at least prevented with an injunction while this case proceeds to a trial on merits.
Counsel, one quick question. The circuit court addressed legal protection and some religious freedom claims. Are they properly before?
I do think that this court can consider these claims because the circuit court was within its rights to raise what it felt as constitutional issues raised by these laws. We did not discuss those in much depth in our briefing, Your Honor, specifically with regard to the religious liberty claims. Of course, there are two amicus briefs in the record from Americans United for Separation of Church and State and Kentucky Religious Coalition for Reproductive Choice and a number of other groups that do address those a little bit more in detail.
Thank you.
Thank you.
Thank you, Counsel. Good.
Thank you, Your Honors. I want to make 4 points in the 5 minutes that I have. Justice Nickel, I want to start out with your question about the vagueness, the alleged vagueness of the health exceptions. The abortion clinics have very good lawyers, and they did not bring a vagueness claim. That, if you look in their complaint, it's not there. I think if you look in their complaint, the claim that's before the court is not a narrow claim that the Constitution protects abortion only in circumstances of rape and incest, which we've talked about. That's not the claim. The claim is a right to elective abortion, a right to abortion for any reason or no reason at all. And so to the extent the court's concerned about these narrow circumstances, as I've said, the court can narrow its injunction, but the only claim that's here is a right to elective abortion. The second point that I'll make is the concerns about the health exceptions. I've talked about those with you, Justice Keller, as well with you, Justice Hughes. I want to be clear that the proper way, our act is amenable to an as-applied challenge to say that in these specific circumstances, the health exceptions are not enough. They've not done that. Ms. Gatton-Erick did not give you a specific circumstance where our health exceptions would be inadequate. I would urge the court, it's not just me saying this, look at what Planned Parenthood did in the Casey case in 1992. Planned Parenthood challenged the health exceptions of Pennsylvania's law, and they identified 3 circumstances that they thought the health exceptions would not cover. I would urge the clinics to do that if they think there are specific circumstances that our health exceptions don't cover. That's an as-applied challenge. That's the right way to do that. Look at Gonzalez versus Carhart, Penn site 167 and 168. Of that decision, they talk about how where health concerns arise in an abortion prohibition, the way to deal with that is an as-applied challenge.
But what if those health concerns are so emergent We know how long it takes, even for an injunction, for something to get through the court. That's just not, that's not feasible.
So 2 points. The act is amenable to a pre-enforcement challenge. The litigation, the SOPA litigation that was discussed in Jefferson Circuit Court that's been removed, that is a pre-enforcement challenge. A temporary restraining order was entered almost immediately in this case, and we were here on a writ, as the court will remember, over the 4th of July holiday. We have the ability to move very quickly on this issue, as these cases demonstrate.
Are you talking about specific medical situations like preeclampsia, pregnancy, or those things you're talking about that would be amenable to some kind of patient challenge? Because I echo what Justice Hughes has said. I mean, 4th of July holiday, the next day is not enough time.
So-
Hours matter, minutes matter in those life and death situations. This court has been quickly since I've been a member, but not that quickly. I mean, we're talking minutes.
So I think the proper way, again, this court hasn't had to deal with abortion for 50 years because of Roe. So I'd urge the court to look at what the U.S. Supreme Court said when it dealt with issues like that. And it said Gonzalez versus Carhart, the language is, an as-applied challenge is the proper manner to protect the health of the woman if it can be shown that in discrete and well-defined instances, a particular condition has or is likely to occur in which the abortion cannot be done or needs to be done. So that's Gonzalez versus Carhart. That's how the U.S. Supreme Court, even under the undue burden standard, allowed health exception challenges.
So a woman is in a life-threatening situation of preeclampsia. Then we're going to add to that burden a court challenge. So if you're a poor woman, maybe you're a single mother, maybe you're there by yourself, dying. Who's going to mount the challenge for you?
Well, Justice Keller, we've already said that preeclampsia, that an abortion is allowed because that is a true risk to the life of the mother. We have been incredibly clear on
The
that.
physicians don't understand that, and that's clear if you read their amicus brief and if you understand what's happening right now in hospitals across the Commonwealth. So understand the AG has made a medical determination about preeclampsia. I could probably list 10 other situations in which the mother's life is at risk. Once again, you've got your life at risk, and then you're going to have to try to fight a legal battle.
Justice Keller, it sounds like you agree with me that preeclampsia and abortion would be allowed in that circumstance, ectopic pregnancy.
That's
This
not
court,
the only one. That's my
this
problem
court's-
with this proposed, I guess, scenario that should take care of this problem.
this court's the final arbiter of Kentucky law. This issue is here. This court could say an abortion in circumstances of preeclampsia, of ectopic pregnancy. You could agree with the Attorney General on those things and say those things as a matter of Kentucky law. The last thing I want to address is Justice.
We need expert testimony on that one.
It's-
I mean, neither the Attorney General nor any member of this court is qualified to make that determination.
It's an issue of law of interpreting our health exceptions, which is exactly what the U.S. Supreme Court did in Casey. If I can, I just want to address Justice Van Meter's concern about sort of the cascading consequences of their position. I did not hear my friend propose a limiting principle to her view of the right to privacy and the right to self-determination. I agree that logically, if the court's going to recognize that right, it may well apply up until term. She did acknowledge that at some point the interest of the unborn child become compelling enough, but the court would have to pick and
Didn't
choose
she
that.
acknowledge that the legislature had passed a 15-week law that's still on the books and that has not been challenged?
So
I think I heard her say that. Maybe I misunderstood. I can clarify when she stands back up. So it may be the scenario where they would like to argue for a broader right, and perhaps they are arguing for a broader right, but they're also acknowledging that should the injunction be affirmed, that just addresses the trigger law and the 6-week law. It does not address the 15-week. And that's what would be on the books of the Commonwealth. And again, it would not be, this court making up its own Roe versus Wade, it would be this court looking to that statute or the 20-week statute, some statute that the General Assembly had passed.
But if this court says that the trigger law and the 6-week law are unconstitutional, we're going to have what we've had with the abortion clinics ever since I've joined state government 5 years ago, litigation after litigation, new law after new law. This court its docket is going to be overrun with abortion cases.
But again, and I think I mentioned this earlier, the statistics you gave us from 2020, the 15-week law would allow 93.3% of the abortions that occurred. And I don't even know, perhaps you can enlighten me, I don't know if those are just all elective abortions or if they include hospital-based abortions. I'm not sure. I think it's every abortion that occurred in Kentucky. But the vast majority of them occurred before 15 weeks, which is what Kentucky would be left with if we affirmed the trial court.
But Justice Hughes, a 15-week law would allow abortions, fetal brainwaves at 8 to 9 weeks, fingerprints at 10 weeks. We've got an amicus brief that talks about fetal pain as early as 12 weeks. So if the court's going to allow abortions at 15 weeks, abortions in those tragic circumstances are going to be
Well,
allowed.
the 15-week ban's not before us.
I think that's correct, but the premise, I think, of Justice.
So that scenario you just outlined would be the choice the General Assembly has made.
I think the General Assembly will be hemmed in from whatever this court is the scope of any alleged privacy right. And I think the premise of Justice Van Meter's question was that there's not a limiting principle inherent in what they're arguing. And in their brief, they've asked this court to create a viability line, which is what the federal court struggled with for 50 years. And if the court were to create a viability line, that would put Kentucky allowing abortions potentially up until 24 weeks, which there's so few countries worldwide that do it. It's, China and North Korea is who we would be in company with if the court were to adopt the line that they've proposed to you.
Thank you, counsel.
Thank you.
Thank you, Your Honor. I want to just address a few things before my time is up. First of all, Justice Hughes, I want to clarify that the 15-week ban, which was part of that House Bill 3 litigation from earlier this year, was subject to legal challenge in federal court under the then existing Roe and Casey framework. But after the Dobbs decision, that 15-week ban has taken effect. So I just wanted to be clear that it was subject to challenge, but is no longer at the moment. Secondly,
But you're not, and you don't have any ability to represent that it will not be challenged. And also, because even if you said, okay, we won't challenge it, that's not necessarily binding on anyone else, correct?
that's a correct statement, Your Honor. I can't control what others do.
But in fact, as I recall, prior to Dobbs, the only abortion providers in Kentucky were in Jefferson County, were they not?
That's correct. The providers who are currently the plaintiffs in this case.
They were the only abortion providers in Kentucky.
That's correct. And just to be clear as well, even prior to Dobbs, even prior to this year's House Bill 3, which gives us the 15-week ban, Kentucky law prohibited abortion after 20 weeks post-fertilization, 22 weeks last menstrual period, and that, which is well before the point of viability, and that point was never challenged, even under then existing Roe and Casey framework. So as this court considers what strict scrutiny application will look like here, there is going to be a point that Your Honors will likely determine that the state interest becomes compelling enough to outweigh the individuals. The reason that line was viability before is not because that's a random point in pregnancy. It's because that's the point at which a fetus could hypothetically live outside the pregnant person. So that is the point that the court considered as being the point that state interest becomes compelling enough. And I would say that it is up to Your Honors whether that is an appropriate line here. But factually speaking, if the injunction is put back in place for the duration of litigation here, abortions would be permitted up to 15 weeks. There is a 15-week ban on the books.
If it were put back in place, what do you envision? It goes back to the trial court for a full-blown hearing, not just a one-day four-witness hearing. Is that what you envision?
Yes, Your Honor. I think we've discussed here there are issues of fact. There are issues that require much more evidentiary record before this court can make a final determination about the constitutional rights at issue here. We did have that one-day hearing before the court, which gave the circuit court enough information to decide that a temporary injunction was warranted, and in no way was that an abuse of discretion. But if we return to the circuit court for further fact-finding, I do imagine it will be a record replete with evidence and expert witnesses that will help the court make the final determination. Specifically, I want to just quickly address the narrow health exceptions and the bans that have been the subject of much discussion here today. And I want to address the Gonzalez language that counsel for the Attorney General cited. With regard to those narrow health exceptions, the circuit court below considered those. The court considered how those would be applied and determined that, in fact, the balance of the equities is such that an injunction is needed even with those narrow exceptions in place. And partly that's because there was evidence before the court that there are risks involved with pregnancy. I think we all understand that. And there was testimony from Dr. Bergen and testimony before the court that pregnant people face risks that are not always known until certain points as pregnancy progresses. So it is not going to be the case that a doctor will have before them a patient to say, I know this patient will face this risk. I know the Attorney General has told me it's okay to perform the procedure, therefore I can do so. Pregnancy is a much more complicated medical experience than that, and it is not practical, and the circuit court agreed, it is not practical to think that those narrow exceptions will be able to allow care everywhere that it may be needed. With regard to the language from Gonzalez, Your Honors, that case was very specifically regarding a little used second trimester abortion procedure. But in holding that the plaintiffs there could have brought an as-applied challenge, the Supreme Court held explicitly the reason that was okay is because even if that one procedure was not available to the doctors to use in certain circumstances, there were other abortion procedures available. So the court said, even if they can't do the procedure here, they can still do a D&E, they can still do a D&C. Here, doctors are foreclosed from providing any abortions at all whatsoever. We do not have a fallback of other procedures like there was in the Gonzalez opinion. Because the circuit court did not abuse its discretion here, Your Honors, we ask that the temporary injunction be immediately reinstated and upheld while this case returns to the circuit court. Thank you.
Thank you, Counsel. Madam Clerk?
All rise. Court of Kentucky is now adjourned.
All right, thank you everyone for staying with us here on Wave Now, watching this stream coming from Frankfort for the Supreme Court hearing arguments today. We're going to have much more on this story. I know that this is something so many of you are interested in. You probably heard some chanting in the background. We're told that there were protests going on outside of the Kentucky Supreme Court chambers. Wave News reporter Sean Bowdy is also working on this story, I believe, along with David Mattingly. And we're going to have much more coming up for you on Wave News at 3, 4, 5, and 6 as well. So thank you so much for staying with us. I'm Myra Ansari. I hope you have a great day.